Oliver Ellsworth, an American lawyer, judge, politician, and diplomat, was a drafter of the United States Constitution, a United States Senator from Connecticut, and the third Chief Justice of the United States. Ellsworth was born to David and Jemima Ellsworth on April 29, 1745, in Windsor, Connecticut. In order to further Oliver's education, his parents sent him to Yale in 1762, which he then transferred from that same year to attend College of New Jersey. There, he received a degree in theology and studied law for the next 4 years. In 1771, he passed his bar exam, and the following year, he married Abigail Wolcott. In 1777, he became Connecticut's state attorney and their representative for the Continental Congress and served 6 annual terms. On March 3, 1796, George Washington nominated Ellsworth to serve as Chief Justice. He served a total of 4 years and 9 months. Some of his landmark cases were Hilton v. United States in 1796, Hollingsworth v. Virginia in 1798, and Calder v. Bull in 1798. Ellsworth served as one of Connecticut's first 2 senators in the new federal government between 1789 and 1796. Ellsworth also served on the Committee of 5 that prepared the first draft of the Constitution. He favored the 3/5 compromise on the enumeration of slaves, but opposed the abolition of the foreign slave trade. As an active representative for Connecticut, Ellsworth in 1787 proposed ideas for the Articles of Confederation during the Great Compromise. While serving his terms, he also helped the state's efforts during the Revolution by managing Connecticut's war expenditures. In 1779, he was assigned to an important role in the government, which was becoming a member of safety which controlled all military measures of the state with the help of the state's governor as well. Before becoming a Chief Justice, Oliver Ellsworth also served on many different committees in the United States. He also served as a commissioner to France in 1799 and 1800. But shortly upon his turn to America in 1801, Ellsworth retired from the public life and lived in Windsor, Connecticut. He died there on November 26, 1807, and was buried in the cemetery of the First Church of Windsor. Although his work is overlooked, Ellsworth's contribution during the upbringing of the nation played a huge role in our successes in the past, which is why he is a historical figure today.
This Supreme Court landmark case involved Hustler Magazine publicist Larry Flynt, and Jerry Falwell. Jerry Falwell was a fundamentalist minister and political leader. The case began on December 2, 1987, and ended on February 24, 1988. The case began when Larry Flynt published an ad on the inside cover of the November issue of Hustler Magazine. The ad featured Jerry Falwell, a very well-known minister and commentator on politics, discussing an incestuous relationship with his mother. In fine print at the bottom of the page, the disclaimer reads, "Ad parody, not to be taken seriously," and the table of contents labels the ad as fiction, ad, and personality parody. Soon after the issue was published, Falwell stated in his complaint that the ad entitled him to recover damages for libel, invasion of privacy, and intentional infliction of emotional distress. Falwell argued that the ad could be misunderstood as actual events and taken seriously. The jury agreed and said Falwell should be awarded $100,000 in compensatory damages and $50,000 each in punitive damages. The trial was held because they wanted to protect the freedom to express ideas and opinions on topics that concern and interest the public. The First and 14th Amendment do not allow public figures and officials to recover damages for intentional infliction of emotional distress by reason of a publication without providing proof that the publication contains a false statement as a fact, while aware that the statement was false, while the First Amendment protects the offensive nature of the ad. The jury ruled against Falwell on the libel claim, saying the ad couldn't be reasonably understood as describing actual facts or events. The jury did rule in Falwell's favor on the emotional distress claim, saying that he should be awarded compensatory and punitive damages. They did not rule in Falwell's favor on the libel claim because the parody does not describe actual facts and the ad's opinion was protected by the First Amendment to the federal Constitution.